Hello, everyone, and welcome to our 8th session in the CEDAW Convention Speaker Series being hosted by Equality Bahamas. We are really excited to be bringing you this series in the lead up to the 30th anniversary of the Bahamas ratifying the Convention on the Elimination of All Forms of Discrimination Against Women, also known as CEDAW, which we see as the Women's Bill of Rights or the Bill of Women's Rights. Today, we are really excited for the article that we're looking at. We're looking at Article 9, which is on nationality. And we all know that this is incredibly important to the Bahamas, particularly as we wrestle with this issue of gender inequality in nationality rights and the issues where Bahamian women are not able to pass on citizenship to their children or spouses, and Bahamian men also cannot pass on citizenship to their children born out of wedlock. So we'll be primarily looking at those first two issues in this session. Please feel free to participate. If you're watching on Facebook, do use the chat feature. We will look out for any questions or comments that you have. And of course, those who are here with us on Zoom can raise their hands and unmute and be a part of this conversation. And our special guest today is from the CEDAW committee. And we have, of course, our very own Marian Bethel, Bahamian attorney at law and member of the CEDAW committee, who has been incredible in helping us to make this series happen, and she will bring the introduction to our speaker for today.
All right, well, thank you so much. Good morning, greetings from the Bahamas, especially to my colleague in Mauritius, my friend. And again, I want to say thank you to Equality Bahamas for just having the commitment to helping with the publicity of the CEDAW Convention, what it means with each article, and how NGOs in the Bahamas can use the CEDAW Convention to advance women's human rights in the Bahamas and throughout the region. So I'm really grateful to Alicia and her leadership and the team, Lauren and Kadisha, who are here with us today to move forward with our agenda. Thank you so much. Equality Bahamas is just doing incredible on-the-ground work in all areas of women's human rights. And so I am really pleased with this particular series. And so to introduce my dear, dear friend, Justice Aruna Narain from the Bahamas. Yeah, she's almost a Bahamian from Mauritius. And we first met in 2017 when Aruna came on the committee. I had already been on the committee for about 2 terms, and Aruna came on towards the end of 2017. And from day one, we have been the best of friends, partly because we are both from small island states, and so we have that in common, and we take great pride in the fact that we are small island states, and we look out for other small island states that come before the committee with great enthusiasm and passion. And so Aruna has been my colleague since 2017, and we've worked together in all sectors of the CEDAW committee. Aruna has brought immense strengths to the committee in terms of her background as an attorney and also as a judge on the Supreme Court of Mauritius since July 2015. And so we have a part of the CEDAW committee, which concerns individual women under the optional protocol to the CEDAW Convention, bringing individual complaints before the committee, where we act as a quasi-judicial body and adjudicate complaints. Aruna has been pivotal in what we call the communications procedure, in overseeing it as vice chair, for one, and just the enthusiasm and the intellectual strength that she brings to the communications procedure that we address. And so there's so much I can say, just because she's my dear friend, my dearest friend on the committee, and also her academic background. So from July 2015 to the present, Madam Justice Aruna Narain has been and continues to be a judge of the Supreme Court of Mauritius. And prior to this, she worked in the Attorney General's office in Mauritius with primary responsibility for vetting bills and legislation, subsidiary legislation. And she was head of the drafting department in the Attorney General's office in Mauritius prior to becoming a judge. And one of the strengths too is that she had appeared as a member of the Attorney General's office before several human rights bodies in Geneva, And so this was something that we also relied on in terms of Aruna's expertise on the committee. So suffice it to say that the time that Aruna has been on the committee, she has brought so much innovation to the work that we do on the committee, several areas of innovation and creativity, and her prodigious intellect and just attention to detail has really made us that much stronger a committee. And so we are so grateful to her presence here. And I will miss her as she has demitted office on the CEDAW committee as of December of this year. Will be her last month on the committee, and we will continue to be the best of friends beyond this. So I turn it over to Madam Justice Aruna Narain to talk with us about Article 9 on nationality, etc. Thank you.
Well, thank you so much, my dear friend Marion, for those very, very nice, lovely, warm words of introduction. And as you said, I'm almost Bahamian, having spent those 5 years on the committee with you, and we always intercessionally sharing details about our respective jurisdictions, so much so that sometimes we feel that we are actually there in each other's country. Thank you so much, Alicia, for inviting me to take part in this exciting article by article series on CEDAW hosted by Equality Bahamas. And I also echo what Marion just said about what a great way this is to give visibility, not only to the convention, but also to the committee and the work of the committee, because you've been hosting different colleagues of mine over different articles. And I think that is a very lively and creative way of disseminating work done by the committee under the convention. So well done, and I hope that other organizations and individuals will go this way too. Marion has already said how close we are. She's my very dear friend. She's also been my mentor on the committee, one of my mentors on the committee when I joined in 2017. And as she said, we are fellow islanders, but we're also fellow lawyers on the committee. And there are not so many lawyers, as you would know. So it was probably inevitable that we would gravitate towards each other. But I think we have supported each other, but also supported each other's work. And I always say that nature abhors a vacuum. And as she said, I'm going to be leaving the committee probably in a month's time, 31st of December, 2022. And of course, there won't ever be a vacuum, because I'm so proud and happy that Marion, my sister Marion, is most probably going to be the rapporteur and vice chair of the committee. And I know she's going to be doing great things in that capacity. I'm so proud that she's stepping into my little shoes. And in anticipation, I'd like to congratulate Marion and also congratulate the Bahamas, because obviously you're very, very ably represented on the CEDAW committee. So very pleased about that. So may I now come to the theme of the day, Article 9 on nationality, which, as I can understand, is a very hot topic for the Bahamas, from what I gather. So let me remain as technical and dispassionate as possible by putting on my PowerPoint presentation, if I may, Alicia. And then at some stage, I will come back to the concluding observations which were made by the committee on the Bahamas in 2018. So that is the cover page. Can we go on to the next one? And I always like to start by looking at what I call the letter of the law. Well, that would be in the domestic context, but here I would actually say, let us look at the actual provisions of Article 9 of the Convention. And I make no apology for reading it out, because I think we have to bear in mind what the Convention actually says. And for your purposes, it is relevant to look at the two different paragraphs, because as you probably know, the Bahamas still has a reservation to Article 9, paragraph 2. So paragraph 1 is about equal rights between women and men to acquire, change, or retain the nationality. So acquire, change, or retain. And as you will note, we don't talk about transmitting. So there's nothing said in Article 9, paragraph 1 about equal rights with regard to transmitting nationality. And if that had been the case, maybe there would have been a reservation from the Bahamas to paragraph 1 as well, because as you know, there is an issue with regard to transmitting nationality from a Bahamian woman to her foreign spouse. So equal rights with women, with men to acquire, change, or retain the nationality. And in particular, state parties shall ensure that neither marriage to an alien nor change of nationality by the husband during marriage shall automatically change the nationality of the wife or render her stateless or force upon her the nationality of the husband. And then we have paragraph 2, which deals with nationality of children. So here, state parties shall grant women equal rights with men with respect to the nationality of their children. And this is where, as you're aware, the Bahamas still has a reservation. Next, please. So in terms of terminology, and this is something which I like to clear at the very outset, because people sometimes ask what is nationality and what is citizenship. And nationality is more of a term or a concept in the international law, under which an individual with a recognized link to a sovereign state is given international protection afforded by that state in relation to other sovereign states. Whereas citizenship is more of a domestic concept, status within a domestic jurisdiction, which entitles one to full membership within the jurisdiction. However, nowadays, these two terms are used interchangeably, almost as synonyms, and to refer to an instrument for securing the rights of the individual in the national and international spheres. Next, please. So again, in terms of terminology, we are referring here to the fact that every sovereign state has a discretion to decide according to its domestic laws. And no doubt this is very important for countries like the Bahamas and other states which have retained reservations to Article 9. According to domestic laws on citizenship and immigration, the preconditions for granting nationality. And I would briefly refer to the general principles for determining acquisition of nationality, with which no doubt most of you would be familiar. Firstly, jus sanguinis, and then jus soli, and then thirdly, combination of both principles. What is jus sanguinis? Of course, this is Latin, and we all are so young that I'm sure we're not all familiar with Latin, but those of you who are familiar with French would know that sang, S-A-N-G, is the French term for blood. So sanguinis, jus sanguinis, acquisition by blood relationship, or as is sometimes said, acquisition of citizenship by descent. And jus soli, again, Latin term, soli, sol in French means soil or territory. So again, a Latin term, jus soli, acquisition by birth within the territory. So by virtue of being born in a particular state. And then third, you can have, as in Mauritius, a combination of both principles. So Article 9 clarifies that this discretion is now limited by the obligation to achieve a standard of equality between men and women. So this is what Article 9, as we have just seen, imposes, that there should be equality between men and women in terms of acquisition of nationality. The three things that I had highlighted before. Thank you for changing to the next slide. So now a little bit of historical background. We know that Article 9 responds to developments in the legal systems influenced by the English common law and civil law on family relations. And just for the sake of interest, you probably know that Mauritius is part of the Commonwealth, but it has a hybrid system because it was colonized by both the British and the French. So we have a hybrid system with both elements of common law and civil law. So that is just en passant. I said that the Article 9 responds to developments influenced by both the common law and civil law. So the common law concept of coverture, with which you may be familiar, and by virtue of which a married woman has had no separate personal identity from her husband. And civil law, influenced by Roman law on patria potestas, that is the power of the father, and also the husband as the head of the family. And these have been incorporated into nationality laws in countries with received colonial legal tradition from both from either common law or civil law, or both of them. Next, please. And as a result, I'm still talking about my historical background. And as a result, we have this principle of dependent nationality. That is, a married woman's nationality is exclusively determined by her husband's nationality. And this is involuntary naturalization. But a woman is also incapable of passing her nationality to her children, and the children's nationality, therefore, is derived from the husband. So that was the historical reason. Next, please. Then gender-biased nationality laws became an issue raised by early feminists campaigning for what we call the right to have rights, which is necessary for broader access to public life. And this issue of discriminatory nationality laws was raised at the Hague Codification Conference. In 1933, we have the Convention on Nationality of Women, and 1957, the Convention on the Nationality of Married Women, which was adopted by the UN General Assembly. Next, please. And that is the what I call the treaty framework. The CEDAW Convention was the first international treaty to refer specifically to women's rights with regard to their children's nationality. So that is the vexed paragraph 2 of Article 9. The other thing I would flag is that Article 9 of the CEDAW is placed in Part 2 of CEDAW together with other articles on civil and political rights. And that is very important. You would know that right to nationality is also enshrined in the Universal Declaration of Human Rights, Article 15, the International Covenant on Civil and Political Rights, ICCPR, the Convention on the Elimination of Racial Discrimination, CERD, Convention on Rights of Persons with Disabilities, CRPD, Convention on Migrant Workers, and also very importantly, the Convention on the Rights of the Child at Article 8. And also we have these two very important conventions, Convention on Reduction of Statelessness of 1961, which entered into force in 1975, and then the Convention relating to status of stateless persons of 1954, which entered into force in 1960. And if you look at our concluding observations on nationality on Article 9, you will find that very often we recommend that states parties ratify or accede to those two conventions on statelessness, because of course these are linked to the issue of nationality, whether acquisition or deprivation. So next, please. So now we come to CEDAW Article 9, paragraph 1, and this is why I took the trouble of reading it out earlier so that we can go directly to the issues that are raised by Article 9, paragraph 1. So as we know, equality and non-discrimination with respect to women's nationality. There is here a recognition that nationality is a critically important status for women's full participation in the community and full membership in the state, as I said earlier. This whole legal identity, this recognition of legal identity. And here, of course, I would refer to CEDAW General Recommendation 21, paragraph 6, which says that nationality is critical to women's full participation in society. And without status as nationals or citizens, women are deprived or the right to vote or to stand for public office and may be denied access to public benefits and choice of residence. Therefore, nationality is a prerequisite for the exercise of civil, political, and socioeconomic rights, such as access to education, healthcare, and housing. Next, please. And one thing that should be clear is that Article 9, paragraph 1 does not guarantee women a right to acquire a state party's nationality, in contrast to other international conventions or declarations such as the Universal Declaration of Human Rights or ICCPR or even CRC. And Article 9, paragraph 1 only requires non-discriminatory methods of acquisition of nationality, as we've seen already, and it complements international instruments or conventions relating to statelessness. Next, please. So I will now go on the issues under Article 9, paragraph 1. Nationality for naturalization. Clearly, what Article 9, paragraph 1 is saying is that states should not apply different criteria to alien men and women marrying nationals. There would be discrimination where an alien woman married to a male national can become a naturalized citizen by choice or with minimal requirements, whereas an alien man married to a female national must satisfy stricter requirements. The resulting problems are that it would limit the national wife's choice of residence and freedom of movement, right to family unity, and spousal contribution to family support when her alien spouse is denied a resident or working visa. Next, please. A second issue is a right to a passport. Article 9 includes the right to leave and re-enter the country of nationality in connection with Article 15, paragraph 4 of the of CEDAW, and thus women are entitled to a separate passport. They should not be made to travel on the passport of their spouse. Also, a right to have a minor child included in the passport and travel with them without restrictions in form of requiring a husband's or father's consent. Next, please. And now I come to the state parties' obligations under Article 9, paragraph 1. They have to grant women the same rights as men to acquire, change, and retain. You remember I put emphasis on those three terms earlier: acquire, change, and retain the nationality, and not to confer it on their foreign spouses. To eliminate specific dimensions of women's dependent nationality by instituting foreign equality measures, for example, making amendments to the Constitution and citizenship legislation, introducing administrative regulations where so required. Ensure that neither marriage to an alien nor change of nationality by the husband during marriage automatically changes the nationality of the wife or render her stateless or forces upon her the nationality of the husband. This is the very letter of Article 9, paragraph 1, as we've seen already. Ensure appropriate access to passport. Sorry, I should have said, can you move on to the next slide, please? Ensure appropriate access to passport, birth, and marriage registration procedures. Establish accessible systems for birth and marriage registration. Access to information and legal aid, very important, to enable women to exercise their rights. And this is a very important for us because Marian and I have both placed a lot of stress on women's access to justice, so legal aid when so needed. Provide migrant and trafficked women with access to legal literacy and assistance in order to obtain residence permits, which could precede naturalization procedures. And here, of course, I would refer to one of our recent general recommendations, CEDAW General Recommendation number 38, which is the trafficking of women and girls, in women and girls in the context of global migration. States parties are also bound to facilitate dual nationality for women and children. And here I would refer to the CESC General Comment 20, with a view to reducing statelessness. Next, please. States parties also have to take into account the impact of citizenship laws on women migrant workers and those trafficked across borders. And here we have the very important concept of intersectional discrimination. States parties have to ensure that women do not only have effective access to formal status and nationality, but also to the benefits of this status. They have to eliminate institutional and structural barriers and stereotypical attitudes, also in courts, ensure non-biased interpretation of the law. The notion of eliminating stereotypes is one which is very important to Mariam. Also states parties have to make available remedies for infringement by state actors, because state parties considered liable for discriminatory actions by its agents, but also for acts of non-state actors. For example, employers or the family, if it's based on inaction on the part of the state. Next, please. Now come to Article 9, Paragraph 2, equality with respect to nationality of children. And this is where the Bahamas still has a reservation, which the committee urges the Bahamas to withdraw each time the Bahamas state party report is reviewed by the committee. So under Article 9, Paragraph 2, we have recognition of women's equal right with men to transmit nationality to their children. And the aim, of course, is to eliminate the concept of one nationality for family members, which is based on a male head of household. This is also, as I indicated earlier, incorporated into the Convention on the Rights of the Child, Article 7 and 8. And dual nationality of children is thus specifically supported by the Convention. Article 9, Paragraph 2 contemplates both biological and adoptive relationships. Next, please. In terms of issues, the issue of transmission of nationality to children. Sometimes children born out of wedlock, born out of wedlock to fathers of the state party's nationality do not acquire the nationality of the state party. And I think this is something which may ring a bell. Being unable to transmit her nationality to her children can undermine a woman's rights with regard to child custody, personal travel, and freedom of movement, and the child's rights pertaining to health, education, and child support in the country of the woman's nationality, and the woman's rights to maintain a family life with care and support for family members. Next, please. The second issue is the issue of statelessness, which, as I have indicated, is a very important one and is one which is frequently invoked by the committee when it's considering the implementation of Article 9 of the Convention. And here we have the fact that interpreting nationality by descent exclusively through the father can result in statelessness of the child when the father is unknown or stateless. The child is also at risk of statelessness if the father's country of nationality bases nationality on birth in the country and the child is born abroad. As I said earlier, this is also in connection with Article 7, Paragraph 1 of the Convention on the Rights of the Child. Next, please. The third issue under this paragraph of Article 9 is that of registration of births and birth certificates. And again, you will see that when the committee is examining a state party under Article 9, it will very often put questions on birth registration and very often make recommendations with regard to birth registration. So delays and problems with birth registration, of course, increase children's risk of being denied access to basic services such as healthcare and education, and challenges in accessing identity documents, especially children born to undocumented women, increases children's risk of statelessness. What are the state parties' obligations under Article 9, Paragraph 2? State parties have to grant women the same rights as men to confer nationality on their children. State parties have to ensure that nationality is conferred on children born to a national and a non-national of the state party with a view to preventing statelessness. They have to amend the law of citizenship, granting citizenship to children born in the territory of the state party who would otherwise be stateless. And of course, states parties have got to accede to the 1954 Convention and the 1961 Convention relating to statelessness, to which I have referred already. And again, you will see that very often in our COBs, in our concluding observations under Article 9, under nationality, we would often urge the state party to accede to those conventions when they have not done so yet. And another very important duty on the state party under Article 9, paragraph 2, is to collect data on stateless women and girls. Next, in terms of obligations, state parties have to ensure and facilitate timely birth registration, including where mothers have no identity documents or registration systems. Obstacles to obtaining birth certificates should be removed. If there is, for example, the requirement of payment of a very hefty fee, or a requirement for parents to present identity documents. States parties have got to deploy mobile teams to issue birth certificates in rural and remote areas and within indigenous communities. So that applies, of course, to big countries with the remote rural areas, but also to archipelagic states with outlying islands. So this has got to be done. You have to facilitate the issuing of birth certificates in those outlying islands and other remote areas and indigenous communities. States parties have got to raise awareness of the importance of birth registration and the procedural requirements for obtaining citizenship. And that is, of course, a very important requirement on the ground, and very often a recommendation that we make in our COPs as well. Next, please. I just wanted to flag some of the positive examples that we have highlighted in our recent COBs, because very often states parties believe that in the constructive dialogue we just criticize and we just sanction, but we also highlight positive examples, and these are some of the positive examples we've highlighted in recent concluding observations, in recent COBs. And I'm just referring to the 2022 ones here. We applauded the fact that Morocco withdrew its reservations with respect to Article 9, paragraph 2 of CEDAW in July 2022. Namibia established an electronic birth registration system. Uganda, a country receiving a high number of refugees and asylum seekers, guarantees their right to birth registration under the Constitution, and this is something that we've applauded in February 2022. So you see, we do highlight positive aspects as well. Next, please. In terms of the outlook, with globalization, nationality laws have acquired greater significance, especially for women who cross borders as migrant workers or trafficked persons. So this is an area in which we are putting more emphasis recently. Now, I have what I call case studies, and I talk about Mauritius and the Bahamas. And this is where I have to be careful. First, because obviously I'm not an expert in Bahamian constitutional law, and I'm so pleased that my friend Marion is listening and is ready to interject or to stop me if I'm going wrong. And also, I have to be careful when referring to Mauritius, because as you've been told, I'm so sorry. This is a very noisy vehicle outside. So I'm a judge of the Supreme Court, so I'm very careful to only refer to facts and to provisions of the law as they stand, and not to make any not to give any advice or to give my opinion on things in which I'm not asked to adjudicate yet. So, well, first maybe we'll talk about the Bahamas. I'm aware that you've had two referenda, 2002 and 2016, and I know that this was the questions when which there were the referenda were linked to 4 proposed bills, and among which was the issue of Bahamian women passing citizenship to children in and outside marriage, Bahamian women passing on citizenship to spouses, and Bahamian women passing on citizenship to children both out of wedlock, but also the very vexed issue of adding sex as a prohibited ground of discrimination. And there's also the issue of an amendment to the Bahamian Nationality Act to bring gender equal nationality law. And of course, it is not for me to comment on the reasons for which the referenda were not favorable to the amendment of the law and the passing of those proposed bills. But from what I've read in Bahamian articles, there is the argument that this exercise was politicized, but also maybe that there was insufficient awareness raising. In 2018, of course, the Bahamas, the delegation, the state party delegation from the Bahamas came before the CEDAW committee, and they were questioned on that issue. And the CEDAW committee made its recommendations in its concluding observations. And I'm sure most of you are aware of those concluding observations, but I think it is worth my dissecting them to be comprehensive on this issue, and also to achieve the aim of the Equality Bahamas on disseminating work on the convention by the committee. So I will just briefly mention these concluding observations in the Article 9. But before we come to Article 9, actually, right at the outset of the concluding observations, the committee, in its principal areas of concern, expressed expressed concern on the fact that there's still this reservation to Article 9, paragraph 2 of the convention, but also to Article 2A of the convention. And this is right in the beginning of the concluding observations, paragraph 9. And then we come to Articles 1 and 2, which are on the constitutional and legislative protection. So not only under Article 9, nationality, but right in the beginning under Articles 1 and 2, constitutional legislative protection. So that shows the strong concern of the CEDAW committee on those nationality provisions. And the committee expressed its concern at the fact that these 4 constitution amendment bills, which were aimed at ensuring gender equality, were rejected in 2016 referendum. The committee also expressed its concern at the absence in the constitution and in legislation of explicit form of discrimination against women, because sex is not one of the prohibited grounds of discrimination, and in particular the fact that under Article, I think it's Article 26, paragraph 1 of your constitution, discrimination on grounds of sex is not prohibited, as I said. So the recommendations of the committee in that regard are that there be a clear time frame for constitutional reform, which should be supported by comprehensive education and awareness raising, and together with the inclusive participation of civil society organizations to expand the constitutional protection from discrimination under Article 26, paragraph 1, to include at least grounds of sex and gender, and also a comprehensive review of the legislation. So that's under Articles 1 and 2 of the convention, right at the outset. So that shows the very high importance that the CEDAW committee gave to this constitutional reform. And then under nationality, under Article 9, we made some more recommendations. And these you can find at paragraphs 31 to 32. And I think Alicia is probably putting them up. I can see some text down, but I missed what exactly was the text that she put up. But I think she's probably putting up those paragraphs 31 and 32 of the COBS. So the nationality, the committee regrets the failure of the referenda in 2020. In fact, I think it's 2002 and 2016 to change the constitution to enable Bahamian women to pass on nationality to children on an equal basis with men. And the committee also, again, expresses concern. You find this recurrent word, concern, on this issue. The committee expresses concern about statelessness, about stateless children in the Bahamas who cannot apply jus sanguinis or jus soli to obtain nationality. So the recommendations under Article 9 are very important. Awareness raising among politicians and the general public, and this is therefore a very important job which Equality Bahamas is doing here, because it's doing precisely this raising of awareness. So awareness raising among politicians and the general public of the need to amend the constitution to repeal provisions that discriminate against women in matters of nationality. Amending the Bahamian Nationality Act of 1973 to include provisions allowing Bahamian men and women to transmit citizenship to children on an equal basis, and take further legislative steps. So that is not only constitution, but we'll be amending other laws to ensure Bahamian women can transmit the nationality to non-Bahamian spouse in line with Article 9, and also that very important stateless determination procedure, which I've already referred to. And I would just I know I'm probably out of time, Alicia, and you're going to stop me very soon, but I would just like to mention very briefly the Mauritian context, because when I looked at your constitution and I looked at mine, it's clear that they're both based on what we call the Westminster model or Whitehall model constitution. Of course, there were a number of other constitutions in the Commonwealth that were based on this model, but many of them have changed the provisions. They've amended, they've repealed, they've enacted different provisions. But our provisions seem to be quite similar. And one big difference is that your Chapter 2 is on citizenship and our Chapter 3 is on citizenship. Your Chapter 3 is on fundamental rights, and our chapter on fundamental rights is Chapter 2. So we've reversed. And I don't know whether that means that the framers of your constitution already anticipated that citizenship would be such a sore issue, but it's right after, the introductory chapter 1. Chapter 2 is citizenship. In our case, it's Chapter 3. So I thought that is quite interesting. And I'm just going to very briefly share our experience with regard to citizenship. And again, I'm going to be very careful because it's not my job to comment on political events. And obviously, in both our countries, this is a very political issue. But we amended the Constitution, and we amended our what we call our Mauritius Citizenship Act, which is very similar to your your Bahamian Nationality Act. I say British because our citizenship provisions are based to a large extent on the British Nationality Act of 1948, to which I think reference is made in your constitution as well as in ours. So our constitution and our Mauritius Citizenship Act provisions were amended in 1995 in the context of a political alliance that was being made. And as I said, it's not my role as judge to comment on political events, and I shall carefully refrain from doing so. I shall only mention significant changes from the constitutional point of view and the provisions and the amendments that were made. The amendments that were made included abolition of death penalty. That's quite interesting, but that was done by ordinary law. The constitution was not amended. And as I said, the amendment of our constitution to introduce sex as a prohibited ground of discrimination, because just like in the Bahamas, our section 16, which is akin to your article 26, did not contain sex as a prohibited ground of discrimination. So we added sex in section 16 of our constitution. And then we also made consequential changes to our citizenship legislation to provide for gender neutral language. So in the constitution and in the Mauritius Citizenship Act, wherever you used to have a father, we now have any of the parents. And I think by and large, we now have gender neutral language, except in one exception in relation to adoption. So now the situation is that children born outside Mauritius would have citizenship of Mauritius at birth if either of the parents is what we call a first generation citizen of Mauritius. And for marriage as well, we refer to any person. We don't refer to man or woman. And I would only add that our section 26 of the Constitution is almost exactly the same as your section 13, so that Parliament may make provision for acquisition of citizenship by persons who are not eligible to become citizens under the Constitution. So that means that in theory, Parliament may by ordinary legislation provide for additional modes of acquiring citizenship. And that would not per se be unconstitutional. That would not be a derogation from the Constitution, but it would be Parliament exercising its powers, which have been conferred upon it under the Constitution. Of course, the CEDAW committee would prefer that the amendments that we recommend should be done by way of amendment to the Constitution, so that you can also amend your Article 26 to have sex as a prohibited ground of discrimination. But if the amendment is to be restricted to the citizenship provisions without touching the discrimination provisions, then arguably, and again, I say arguably because I'm not an expert in Bahamian constitutional law, but arguably this can be done by ordinary law under your section 13 of your constitution. Under all reservations, because as I said, I'm not an expert in Bahamian constitutional law, nor can I purport to give any legal advice whatsoever. So if that is of any interest to you, you can maybe look at our bills of 1995. Probably that can be accessed on the internet, and if it can't, then I can send them to Marion or to Equality Bahamas. I think it would be an interesting, not precedent, but interesting story, legislative history in another Commonwealth country with very similar provisions. So maybe I should stop here. I know I've gone beyond the time that was allotted to me. I hope that was clear enough. If it wasn't, I'm happy to answer any questions. And if I need help, Marion is standing by. Thank you very much.
Thank you so much, Aruna, for this great detailed walkthrough of Article 9 of CEDAW that's focused on nationality. It was really helpful to have a look at it and have it really broken down into smaller parts. And also the case studies are really helpful for contextualizing it and getting a better understanding of what it really means and what nationality rights look like and how we can make them gender equal. You mentioned a couple of times the Bahamas having reservation on Article 9. I think it's 9.2.
9.2.
What does that mean? What does it mean to have a reservation? Why do states do this, and why is it allowed?
Oh, why is it allowed? That is a sole issue with the CEDAW committee, because the CEDAW committee is not happy at all with any reservation to any provision of CEDAW. But obviously, this is something which is allowed under public international law. There's even the Vienna Convention on the Law of Treaties, which provides for reservations, and that the idea being that sovereign states are free to decide whether they want to subscribe to the whole of the treaty, or whether they want to subscribe to the general spirit and to most of the provisions of the convention, but then they are not ready yet to subscribe to all of it. Well, at least that's what we think. We hope that a reservation doesn't mean it's going to be a permanent reservation. And then, so they are allowed under public international law to enter reservations. But the Vienna Convention on the Law of Treaties, if I'm not mistaken, says that a reservation does not really hold if it goes against the spirit of the instrument. And in our view, entering reservations to any of the provision of CEDAW goes against the spirit of the convention. So this is something we do not encourage at all. We strongly discourage, and we systematically tell the state party that it should withdraw within a specified timeline any reservation that they have. And in your case, you have reservation not only to Article 9, paragraph 2, but also Article 2A. So we would, as we've said, each time you've been reviewed by the committee, and as we said again in 2018, we strongly urge the Bahamas to withdraw its reservation to Article 9, paragraph 2 and to Article 2. And this is not something that the CEDAW committee looks very kindly on.
Absolutely.
Thank you. For those who have joined us on Zoom, please feel free to put your questions, comments, challenges in the chat, or indicate that you'd like to speak by using the raise your hand function. I see that we have a question in the chat. How are the children who are not accorded Bahamian nationality treated in the Bahamas, with examples, healthcare and education? So,
Well,
Mariam, do you want to take that?
Yeah, I think that'd probably be for Marion, because I'm not an expert in Bahamian law. But what I would say, and that is a little bit linked up to what I said about Article 9, paragraph 2, and that is the issue of recognition under the law. So if you're not given nationality, or if your birth is not registered, you're not recognized in that particular country. So that obviously affects your enjoyment of all your rights in that particular country. So that is the big objection. It's not only a question of having a passport and being able to travel. It's the fact that you're denied enjoyment of your rights. So that is the issue, as I highlighted earlier. Otherwise, Marion, maybe you can talk about Bahamian law, which is not an expert.
All right. Thank you, and Aruna, you've said it correctly. You know that this is all related to Article 9, and it's an absolutely on-point question. Now, I'll address the issue of education, because we have an Education Act which says very clearly that every child in the Bahamas is entitled to go to school and to be a part of our educational system. So the Education Act is the act that is activated in regard to a response to this question. Even if you don't have Bahamian nationality, under the Education Act, you have a right to go to go to school and be educated. Now, in regard to the healthcare system, I'm not aware of any particular legislation that addresses this issue, but I do know that once you go to the public health institution in regard to health, you can move through the healthcare system. At least that's in theory. And practice, I don't think it's quite as easy as that. Alicia, do you want to weigh in?
Yes, I've done a little bit of digging on the issue of health, and it does appear that use of and access to the public clinics and hospitals is possible. People have been able to use it if they do not have citizenship, whether they're documented or not. I think one of the areas that we definitely saw this make a big difference is in disaster relief. So we experienced this firsthand, and this is one of the questions that I have for you, Aruna, about the way that the committee looks at a particular article alongside another related article or another convention or declaration or other agreement that the country has made. So we had this devastation from the Category 5 hurricane in September 2019, Hurricane Dorian, and we saw that people who could not prove their nationality or could not provide government-issued photo identification were being turned away from a lot of places where they were trying to get assistance. So this is one of the ways that not having access to a nationality, in addition to the treatment of migrant people, of course, impacts access to another set of rights. And curious about this, I looked at the general recommendation, I think it's 37 on disaster. And there are some references in there to the different rights and also to the fact that people can be displaced within a country, but also outside of a country. And as the climate crisis worsens and becomes more and more real to us, there are conversations about having to relocate, being forced to migrate. And I'm wondering, like, what does that look like for someone who doesn't have a nationality? What does that look like for stateless people? Have there been any conversations about this? Has this come up in any state reviews?
Well, very much so, Alicia. And I think by now you're such an expert on CEDAW that in your question, there was the answer as well, because I was going to refer to the general recommendation 37 on climate change. And where we talk about this need to have documentation, because otherwise, in moments of vulnerabilities, because this is what it is, then this makes things even worse. So this whole need to have birth registration, which is something we put a lot of emphasis on, but also being recognized as a citizen. And ensuring that people are not stateless, and children in particular are not stateless, women and girls are not stateless, is something that we have put stress on in the GR. And you referred earlier on to the fact that we also talk about intersectional discrimination. So if there are rights at a particular article of the convention, and then we find that there is something which another form of discrimination which increases the vulnerability, this is also something that we will approach in our review. I mean, to give another example, Indigenous women, for example, quite apart from the issue of stateless women or women whose births have not been registered or discrimination, there's also the fact that the Indigenous women have problems of their own specific to them. And again, we have a general recommendation that is 39, I believe it is, where again, we talk about that. And again, we talk about issues like birth registration, if I'm not mistaken. So I'm not sure I've answered your question, because I think in your question, there was already the answer. And we do put questions. I mean, in one sentence, we do put questions on such matters when state parties come before us. So I think it's a question for Marion.
Thank you for that. Yes, we have a question for Marion about what you said about education being accessible, Marion. Someone is asking what levels of education the Act covers?
Yes, definitely primary school. And I think it's up to the age of 16 years, which is the same for Bahamian children. So I guess that's partially high school.
Yeah.
Mm-hmm.
Basically,
I
K to 12 is.
Yes.
Do we have any other questions about Article 9 on nationality or the concluding observations, which are the recommendations that have been made by the CEDAW committee?
And I'm very happy to see that another good friend and colleague is here, Rhoda Reddox, who I don't know if she wants to add anything to what I or Marion have said. Maybe she can do so as well while we're waiting for the questions.
Hi, Aruna. Thanks so much
Hi.
for that very detailed presentation. I kept thinking how much your legal experience has contributed to this presentation, because I have also done Article 9 from time to time, but I think that that you really highlighted the legal aspects which are critical. I think that in the Caribbean region, we have many challenges with Article 9, even though it's it's not, there may not be reservations. So I think that it's very important that issues of statelessness and citizenship be brought out. For example, we have a very a dilemma right now being discussed in our society about the women and children who were taken by their husbands to fight in ISIS and are now in camps in Syria. And there are demands for them to return home. And of course, there are some people who are against it. But again, these are our citizens. They have our nationality, and we do have a responsibility for them. So I think that this is another area where that issue of nationality comes up. And even though sometimes it's in difficult circumstances, I think states have to develop mechanisms through which, this could be addressed. I think also in the Southern Caribbean and probably elsewhere, we've had large numbers of Venezuelan migrants come into our countries. And in some of our countries, they don't have access to education, which I think goes also against the Convention on the Rights of the Child. So I think that there's a lot of work that we need to do in this region in the area of nationality. Thank you.
Thank you so much, Rhoda, and for stepping in and giving the sort of a wider Caribbean context. That was very useful. But also when you referred to ISIS, and that reminded me of the very famous Shamima Begum case, which probably most of you are aware of. And when the United Kingdom was reviewed, I put a question to the delegation on the Shamima Begum case. Shamima Begum went to, she was one of the ISIS followers, and she was deprived of her UK nationality in such circumstances that she's now stateless, and she's still there, and she's not allowed to go back to the UK. And I put a question to the UK delegation, and they said they were going to give a reply afterwards. And I don't think we'd ever got any reply. So that was an interesting point to raise. Of course, in the case of Trinidad as well, there are some issues. And yeah, you're quite right to talk about these other implications for the Caribbean as well. So thank you for that. Oh, there is a question for me. I mentioned, can she clarify what the difference is for adopted children with regard to the transfer of citizenship? She mentioned a difference. Oh, well, she spoke of the current status. No, I mentioned adoption because for the time being, this is the only case in which we don't have gender neutral language with regard to citizenship. I think it only refers to the father, adoptive father, and obviously that is wrong. So it's only if the adoptive father is Mauritian that the adoptee will acquire citizenship of Mauritius. So that is something which has to be attended to, and it's often highlighted as an example of the discrimination still remaining in our law.
Mm-hmm.
It's the same for you as well. Yeah.
So does that mean then that a woman, a Mauritian woman who is not married cannot adopt? Is that what we're?
No.
Sorry.
No. I mean that is another issue. That is another issue as well.
Mm-hmm.
Yeah, I won't go into that. But what I wanted to say is that if there's a couple and the Mauritian, it's Mauritian father and a Bahamian mother. Sorry, I should say the Mauritian mother and a Bahamian father. The Mauritian mother will not be able to transmit its citizenship to the adoptee. Whereas if they had been a Mauritian father and a Bahamian mother, the Mauritian father would have been able to transmit. So this point has got nothing to do with whether a woman on her own can adopt. This is in the context of a adoption by a couple.
Got it.
And reference is only made to the father, and that is like a relic of the time when citizenship was being passed by the father only and not the mother. So it's just still there in the Mauritian Citizenship Act. And this is the context in which I mentioned adoption. Anything else?
Looking at the concluding observations from the 2018 review of the Bahamas, the concluding observations say that the Bahamas needs to set a clear time frame for constitutional reform. And it's specific about that reform being on protection from discrimination on the basis of sex. It doesn't speak to nationality. So that's the recommendation under Article 2. And then later on, the recommendation under Article 9 is to make amendments to the Bahamas Nationality Act.
No, but also Constitution. You remember I said under Article 9, we recommended that there be awareness raising among politicians and general public on the need to amend the Constitution. So our preferred choice is still to amend the Constitution to repeal provisions that discriminate against women in matters of nationality, and also to amend the Bahamian Nationality Act 1973. I keep saying British because of the British Nationality Act of 1948. So amend the Bahamian Nationality Act 1973. But first, we talk about amending the Constitution, and we talk about awareness raising awareness raising among politicians, the general public. So definitely that is our preferred option, even when we talk about nationality and even when we make recommendations under Article 9.
So the CEDAW committee is looking for the Bahamas to do both these things then. So in the interim, deal with this in a temporary fashion using ordinary legislation, but ultimately there needs to be constitutional reform.
That is very clear in our recommendations. And that is why we raise it first under Article 1 and 2. We talk about the constitutional protection, and then we also raise it under Article 9. And it's quite clear from the recommendations, and that this would be our preferred course of action. But of course, if further legislative steps can be taken to attend to the problem, to the issue in a more expedited way, then that is obviously up to your government. Although I understand there are some reservations as to whether that would be constitutional or not. And as I said, it's not for me to express an opinion on that. But so far as the CEDAW committee is concerned, it is quite clear that our preferred recommendation, our preferred course of action is for the Constitution to be amended. It's neater.
Okay. That'll definitely take some work. I think we've gone through 2, and the last one, I think we learned quite a bit the hard way about referenda and how they work and how to prepare for them. So, Equality Bahamas has been working on a plan for the next referendum and what that should look like and sort of the timing of it, because we found that in previous times it has come just too close to a general election, which is generally the time that people are quite dissatisfied and not trusting of the government or anything that it proposes. So we've seen that the timing is likely to make a very big difference. So that's a long-term strategy, but I think the legislation is important to have that done immediately so that people have a way to access citizenship, that children and spouses have a way to get access to citizenship in the Bahamas.
And your next report before the committee is probably due. because you were last reviewed in 2018. Obviously, I won't be there quizzing your delegation, but I will certainly follow the process and see whether any progress has been made by the Bahamas in that direction. I know Marion Bethel probably will keep up the pressure.
Yes, thank you for that, Aruna. And I completely agree with you, Alicia, when you talk about the timing of a referendum, because our tribalism, tribal politics closer to an election sets in deeply and in a very hard and unrelenting way. So separating or putting as much distance between a referendum and an election is really, really important. I agree with you there. And also on the issue of legislation, legislation that can address the matter in the meantime, I think also is the way to go. And as we were talking before coming on this session, the amendment is still pending to the act to allow women to do this under the legislation. But I'm also reminded that under policy regulation, women whose children are born outside of the Bahamas to themselves and to a non-Bahamian can, under policy guidelines right now, apply for their children to register as citizens in the Bahamas. But we do need the legislation, and ultimately we need the change in the Constitution itself.
Yes. And may I venture to say that as you celebrate your 30th anniversary of the ratification of CEDAW, that might be a nice moment to amend your laws and your constitution, to make, and also to withdraw the reservation.
Yes,
that is very important to us.
Yeah,
absolutely. I think with this 50th anniversary of independence coming up, I really think the pressure from women in the Bahamas, citizens period, should be to bring pressure on the government in regard to this constitutional amendments, the legislative amendments, all of the laws that discriminate against on the basis of gender in the Bahamas need to be amended and looked at very carefully. So I think with the advance of the 50th anniversary, it's a really good time to lift up the volume, raise the volume on all of these issues and see how we can make things happen short term.
And with Equality Bahamas championing this, I think you're going the right direction.
It'll be a big year next year.
Yes.
A big year. So we started preparing early by having this series and helping people to get a better understanding of the convention itself and how it applies to daily lives. So one of the challenges that we found when we're advocating for certain things and using CEDAW, because we know the strength of CEDAW, a lot of just ordinary citizens are feeling as though it's a foreign imposition. I don't understand what this is. Why do you keep talking about CEDAW? So we recognize that not only are we talking to governments about something that they understand and calling them to account on their obligations, and particularly unfulfilled obligations, but we also have to have the same conversation with our peers, with fellow citizens, with the rest of civil society, and understanding the power of this convention and how it can help us to move forward, and really breaking it down into these sessions like what you're doing, what Rhoda has done, and many other members of the committee so far, I think is making it more digestible and more applicable to our realities. And, you know, we're just sort of building up to that 30th anniversary and to, as Marion mentioned, the 50th independence, to make a call for a number of changes on this issue of nationality, on the issue of discrimination that is pretty much built into our Constitution. You mentioned earlier the need for a review of all discriminatory law that was recommended by the CEDAW committee, and that's actually happening. That's taking place. UN Women has been involved in that process. We're still waiting for the final report. We're hoping to get it early next year and being able to use that as well as another tool to advocate for the changes in these laws and recognizing that discriminatory laws, gender unequal laws are a form of gender-based violence. It's structural violence, it's institutional violence, and we need to frame it in that way and understand the way that it impacts people's behaviors as well, and the interpersonal violence that we're seeing definitely a rise in the reporting on it, which is, I think, shocking for people who don't work in this space and know what's happening within homes and communities. So I think all of this is really important, really interconnected, and we're just so grateful that you are here. You've joined us to talk about Article 9 and giving us a fuller understanding of it. So thank you very, very much for being here with us today.
Well, thank you very much, Alicia. It's been a great pleasure, and I'll keep following developments in the Bahamas. I don't think Marion will allow me not to in a way, but I will. I definitely will, with great interest. And it's been a great honor to be with you all. Best of luck already as you start preparing for your celebration of your 50th anniversary next year and the 30th anniversary of the ratification of CEDAW. So Marion, probably next year is the year when I should visit the Bahamas.
Absolutely.
All the best. Bye-bye.
Thank you so very much again, Aruna, for being here with us. I really appreciate it. And I did forget to say at the very beginning, your stellar work as vice chair of the CEDAW committee, and also as rapporteur of the CEDAW committee. And you very gracefully said that I will be taking over those two, or I'll be ascending to those two positions that you held on the CEDAW committee. So I will do my best to live up to the high bar that you set as vice chair of the CEDAW committee and rapporteur.
Well, I'm sure you're my very dignified successor. Now you're going to do even better. Thank you so much.
Thank
Bye-bye.
you. Thank you for today.
Thank you, everyone, for joining us. This is the last session in this series this calendar year. The next one, Lauren is going to share the graphic in a second. The next one will be on January 21st. We'll be looking at Article 10, so please join us then. You can register now so you don't forget to do it later. It's tiny.cc/CEDAW10, and we'll get that in the chat for you. So you can click the link. It's tiny.cc/CEDAW10. Yesterday was the start of the Global 16 Days campaign. It was the International Day for the Elimination of Violence Against Women. And as usual, Equality Bahamas has a series of events that we are hosting. Join us tomorrow for a free yoga session. You can register for that at tiny.cc/16daysyoga. That's tiny.cc/16daysyoga. That session will start tomorrow at 8 in the morning. On Monday, we have a session with Jessica Russell, who is a therapist, and Candy Gibson, who many of you are familiar with from Families of All Murder Victims, also known as FOAM. We'll be talking about the impact of femicide on the families of the victims. You can join us for that session on Monday at 6 p.m. That's Monday, November 28th. Register at tiny.cc/16daysfamily. We'll get that in the chat for you, tiny.cc/16daysfamily. And for information on the other upcoming events, stay tuned to our social media channels. It's Equality242 on Facebook, Instagram, and Twitter. Lots of events, too many to mention now, so please follow us on our social media channels to get more information. Thank you for being here, and we're looking forward to seeing you tomorrow at 8 in the morning for yoga.